publication of the report of Arlene Indos, we are now in Social Security System or SSS. Given under Republic Act No. 8282, all employees employed by private companies are obligatory to apply for membership with the Social Security System or SSS. So, kanang empleyado nga na-employed sa mga private ng mga companies kay i-obligate sila nga magpa-member sa SSS or Social Security System. This system offers private employees and their family security against disability, sickness, old age, death, or other such cases that could make them unable of continuing their employment. So if ever na mahitabo sila or sa member, for example, madisgrasya or magsakit or mutigulang na ba siya, na siya madawat nga kwarta from SSS. Kaya member siya sa SSS. The Government Service Insurance System or GSIS is its equivalent system for public employees in the Philippines. So, kung ang mga private nga employees kay SSS, so naapod sa public employees, mo po na ang gitawag nga the Government Service Insurance System or GSIS. Both employer and employee are compulsory to send monthly contributions to SSS. So, pili lang kay ang employees lang ang maghatag og monthly income or maghatag og mag-atag og income through silang sweldo, appeal ko ang employer. The contribution amount is based on the employee's actual monthly salary wherein the employer is mandatory subsidize 70% of the required amount while the remaining 30% is taken from the employee's monthly salary. So, ang ginahatag sa employer every month is 70% or it's mandatory to subsidize 70% of the required amount. Then, ang remaining 30% po na siya ang ginahatag sa mga employees. Says with any number of employees must register to the Philippine Social Security System, the following documents should be submitted. So, muna yung mga ipan-submit sa mga businesses nga na daghang employees na kinahanglan mo ka og SSS. Number 1, employer registration form or Form R1. Number 2, employment report form or Form R1A. Number 3, list of employees specifying their birth dates, positions, monthly salary, and date of employment. And lastly, number 4, articles of incorporation by laws and SEC registration. Legal mistakes made by startups. So, na po mga mistakes nga mabuhat ang mga startup business. When beginning a new startup, the owner can be confronted with sub-business and legal challenges. The following are some of the more common challenging legal mistakes experienced by small and growing companies. So, muna siya, kaning ako mga pag-istorya is muna siya ang mga mistakes, legal mistakes nga mabuhat sa mga startup or mga new business woman or man, mga new businesses. Number 1, not making the deal clear with co-founders. An entrepreneur should agree with co-founders about the details of the business relationship. Without details, the business will later on face legal problems such as litigation between Zuckerberg and Winklevoss of Facebook. This agreement can be likened to the prenuptial agreement. So, it is very important nga magkasinabot ang entrepreneur o bantayaw ang iyang mga co-founders kay about sa details sa ilang business. It is very important kay kung dili sila magkasinabot, so mabaliwala lang ang ilang business or like mahimo bitaw siyang kanang ma-bankrupt like that. So, dapat yun magkasinabot ang mga co-founders o ang mga entrepreneur. Number 2, not beginning the business as a corporation or LLC. The legal form to operate the business is one of the very first decisions founders must make. Often, businesses start with no lawyer consultation, hence they suffer from higher taxes and big amount of liabilities. These things could have been avoided if founders had structured the business as a corporation or a limited liability company. So, dapat siya ang pinakaunang buhaton sa isa ka businesses kung magsugod siya og business, kay dapat mukha sila lawyer or a consultation, magngay sila consultation sa usa ka lawyer, kay para through that makuhaan ay lang mga dagko na mga taxes o mga big amount of liabilities. Dapat para malikayan ni siya ang yung company is makabayad siya og mga dagko na mga taxes o mga big amount of liabilities, dapat the business as a corporation or a limited liability company. So, dapat ang founder is, dapat ang business is ihasang himong corporation or through the lawyer. Kaya di ba mag-consult siya sa lawyer, dapat na siya consultation sa ka lawyer. So, ang lawyer, ang iyang trabaho is dapat ang business, sa ka-business, sa ka-tao is dapat may mo siyang limited liability company or LLC. Selecting a company name that has trademark issues, domain name, problems, or other issues. It is like vital to do research first before selecting a company name. So, dapat, ka mangita og company name, dapat mag-research sa ka. This way, trademark infringement or domain name problems can be avoided. So, through sa imong research, ito ni mo makitaan sa mga dili ni mo pwede buhaton or dili ni mo pwede i-himong trademark or company name sa imong company. An entrepreneur may be trespassing on someone's trademark if he uses a mark that is likely to cause mix-up among customers as to the source of the goods or services. So, entrepreneur is pwede siya ma-trespassing kung ang iyang gigamit nga trademark kay nanapoy laing nagamit. 4. Not conforming with securities laws with allotting stock to angels, family, or friends. Failure to obey with applicable securities laws requirements can result in considerable business disadvantages for the founders and the startup company. Number 5. Not sufficiently considering important tax considerations. Startups are required to pay attention to numerous tax issues connected to their business. So, dapat atimanan dyan sa mga businesses ang ilang mga tax, ilang mga bayaran. Without good planning, founders can be implicated or their startups accountable for inadvertent and unforeseen taxes, fines, and penalties. Number 6. Not having the right legal counsel. Often, startup businesses employ inexperienced legal counsel who could be their friends or relatives to save on expenses. So, sagara sa mga businesses is mag-hire sila og mga inexperienced legal counsel. It's either be their friends or relatives lang para makasave sila og expenses. But wala sila kabalo nga. This is a misguided effort which denies the founder the advice of experienced legal counsel who can help escape numerous legal problems. So, wala sila kabalo nga kana dapat yun is mag-hire gid sila og experienced legal counsel gyud para matabangan sila nga maka-escape sa mga daghan pang mga legal problems. Number 7. Not keeping correct corporate and HR documentation. Companies are often messy in maintaining suitable corporate and employee or HR related records. So, ang mga companies is kanang dili bitaw gid nila gina-maintain ang kanang sakto bitaw nga pag-ipos sila mga documents. This can become challenging when the company tracks financing or is involved in claims or lawsuit with an employee or regulatory agency. Number 8. Not prudently considering intellectual property issues. If the owner has developed a unique product or technology or service, he needs to study the applicable steps to safeguard the intellectual property he has developed. So, dapat yun, ang owner, kung mag-develop siya ng mga unique product, technology, or service, dapat yun is yung i-apply ang steps to safeguard the intellectual property na iyang i-develop. In this way, he avoids trespassing the intellectual property rights of third parties. So, dapat yun gina-check or gina-double check yun niya ang pag-himo niya or pag-develop niya ng mga unique product ay para malikayan ang trespassing sa intellectual property rights of third parties.